Good evening, everyone. Thanks for coming. We are having a joint meeting with the Planning Board and the ZBA and the Town Board of the Town of Cleveland. I can read this meeting now if you'll join me for the pledge.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The record reflect that all 4 town board members are here. Are there any members missing from the planning board? No. All present and accounted for?
We're all present.
All right, so full house. Our first item to discuss is site plan review. Everyone has a history of it. I think we would like to walk through the history and between the 2 boards and see if there is an issue that we can bring up in discussion and how we want to move forward with our site plan review for the town, site plan review law, moving forward with the businesses. I think it probably would be appropriate if we started town board with any issues that they had come up with the preliminary work that our legal team has done. Yep.
And I think just for background, Mr. Schmidt early on did just raise the fact that this is sort of a unique situation, right, where we have both boards together. I think the intent really is just to solicit feedback, to bounce ideas off each other, find out if there's any takeaways that the town board, would get from the planning board, which would result in future action by the town board. Town board's not in any way trying to dictate what the planning board does or not. We're just trying to solicit some feedback, and this seemed like an informal way, rather than communications back and forth to get that.
Yeah. We don't want there to be any thought outside of this room where there's any sort of impropriety or that we as a town board are trying to influence members of the planning board and the board of appeals.
Mr. Boomer, would you like to take off for the planning board and the zoning board of appeals? Any issues? Did you have a chance to review?
Yeah, so far I don't know how anybody else on the zoning and planning board feel about it, but I don't see anything that really, throws up a red flag. I am a little curious. It's not really from a zoning and planning board standpoint, but it says that, if I'm reading it correctly, that the law was in place and that it just never, for whatever reason, wasn't being enforced. And so I'm a little concerned about going back and penalizing business owners after the fact, because really I feel like it's on us if we weren't enforcing it. It's not on the applicant. I know usually when we have gray areas and stuff on the zoning and planning board, usually the burden falls on the town or the authority rather than the applicant. So that's just one concern I had. But other than that, I don't really have a problem moving forward, as long as we can keep things moving in a timely manner so that we don't hold some of these projects up too long, but we do it for other projects all over anyway. I don't know what Mr. Collins or anybody else feels.
Since you've been here, have you done site plan review?
For the industrial?
Yeah, anything.
There was an amendment when I first started for the industrial park. That has been it.
Yeah, we've done site plan reviews for other people though. Right?
Yes. Yes.
What he's saying is, in the 20 years the industrial park's been there, there's been no site plan review done for the industrial park? Is that what you said?
Not since I've been here.
Not since you've been there?
Since he's been here.
Yes. but not since I've been.
And I would just note too, and I am completely, I have no sense of the history in terms of what's been before that board or not. It does strike me that there were likely situations where there'd be a project that was maybe that required a special use, or that maybe required a subdivision, so there may have been projects that could have been subject to site plan review. It really wasn't applied for whatever reason, but they still came before you because they were subject to a special use permit approval, and or, they're involved in subdivision, so they may have been there, just with a slightly different lens.
I mean, it is hindsight, but was it failure of the applicant or failure of the town? Why this wasn't occurring? Have we gotten to that, like, just the applicant didn't file the paperwork and bring it forward, or?
No, I mean, we have a schedule in our zoning code. And the schedule says, and the schedule has always said, that for the I-1, I believe for the I-2, for the I-2, that in the last column, required site plan review, approval by planning board, zoning board of appeals. For I-1 and I-2, it says for all except principal uses.
There were triggers.
So we have had a document that's been included in our zoning code that basically, exempts site plan review from the I-1 and I-2 for principal uses.
So I think that was really the source of the confusion. Historically, it appears that there were carve-outs for principal uses in the industrial zone. In 2007, they started talking about having a formal site plan review law. Looks like they considered it in 2008, 2009, but it didn't have adequate exemptions for agricultural purposes, so then they brought it back in 2010, 2011. And ultimately enacted that. There were requests at the time that industrial uses continue to be exempt. The town board approved the local law without including those exemptions, and it contained a repealer clause. From a legal perspective, the effect was that language in that schedule would have been repealed, but I don't think it was ever cleaned up. And so that just created the confusion, I think, that's been out there for the last 7 years.
So the planning board was following exactly what they should have been doing.
Correct.
Well, I think they should have been following, I don't want to say it that way. I think that the 2011 site plan review law was in effect and was applicable. There was some confusion as a result of the schedule that remained in the zoning code, and so they didn't apply it in all circumstances.
So moving forward, would a solution be that the planning board and the code enforcement and possibly the supervisor's office work together to sort of get an idea of industrial park and industrial zoning, how to move forward?
I mean, it strikes me, Mr. Boomer suggested that certainly going forward, maybe there'd be a consensus that you want to look at these. To be able to do that, I think you need to have a sense of the status quo so that you know if there's an expansion or a change in the use or some other thing that will trigger site plan review in the future. So it might make sense to sort of just try and do that inventory to get a handle on what the current state of affairs is. I would maybe leave that to the building department and perhaps the planning and zoning attorney if we could retain him for that purpose. And again, sort of leave it to those departments to try and figure out what the current state is.
How would that work practically? They would get together and actually do a site visit?
I think they try and do an inventory of what's out there, yeah.
Okay.
I guess, Mr. Riley, I'm just a little bit confused as far as why your understanding or interpretation is that there's a discrepancy between the schedule and the actual code that's in place. Like, where in this code does it say that the site plan review should be done in the industrial zone? What doesn't say what it says it here. Or doesn't say it here.
So if you track back through the zoning, that schedule has always been,
This schedule.
the form of that schedule has long been in place prior to 2011. When this local law number 1 of 2011 was enacted, it described the types of projects that would be subject to site plan review, some of which would encompass industrial type projects. It doesn't say industry, it just says all sort of,
So would you be referring to then 136.4 subsection B?
well, so say 136.4 just generally describes all the types of projects, whether new or expansions of old, that would be subject to site plan review. 136.5 then details the particular limited projects that are not subject to site plan review, and industrial isn't included in it.
Okay.
And if you look at the minutes, there were effectively requests that this not be applied to industrial uses. The town board did it anyways.
Okay.
And if then you look at 136-14 is what we would call the repealer clause, which
Correct.
basically says if there's something else inconsistent in zoning at the time we adopt this local law, number 1 for 2011, it's repealed. Okay. And although they then didn't clean it up, I mean, that's the legal effect.
So basically, the issue or the discrepancy is 136.5 and the fact that it doesn't say anything about the I-1 or I-2 schedule.
Can I participate in this discussion, or do I have to wait?
I think it would be helpful if you did.
So, Nick Laraway from Carver's, I guess just for the record, this is discussing all industrial property, not just our industrial park, right?
Correct. No, absolutely.
Just for the record, which versions of the attachment that Mr. Schmidt is sharing do say that site plan is required for principal uses? Because we've been looking for what's available online and have not found one, including the one that we saw came out with the local law. So even with that repealer clause, if this attachment has been consistent through all of that, would that not be incorporated with the local law as approved and enacted back in 2010 or 11 or whenever it happened?
From a legal perspective, I don't think that's the effect, right? The local law contained a repealer clause that effectively repealed anything inconsistent. That language was in there beforehand, but if you look at the sort of broad definition of the types of projects requiring site plan review, it talks about construction of any new structure, development of any new uses. It's broad, right? And so that would encompass all of those types of projects or developments, except for what's specifically excluded. The next section actually delineates what's specifically excluded, and that's residential and agricultural. And just as a matter of statutory construction, we have to assume that the board intended that result, that there's a broad application of site plan review with the limited exceptions of residential and agricultural projects.
Even though section 136 has references to the chart that has been in effect prior to, concurrently, and after the law went into effect?
I'm not sure what you're specifying in terms of section 136 having that reference, but absolutely, I would take the position that that this would apply to the industrial uses. And when you, this isn't just my opinion, right? When you look back at the minutes, owners of businesses in the industrial zone came out and said, we don't want you to apply that local law or adopt that local law because it will apply to our businesses. And the town board did it anyways.
And I guess just asking the question, certainly many of the players that were involved during that time are no longer around. I know Larry Conrad was supervisor and heavily involved as code enforcement, and he's passed away. But have you guys consulted with the individuals such as the town and planning board attorney that was around during those times?
I've spoken with Mr. Wookich, correct? Yeah. What, pardon me?
Andy Brick?
I've not spoken with Andy. I did speak with the town attorney at the time, David Wookich.
And I guess just from prior meetings when we've had discussions about zoning, I know that zoning isn't, one of your primary things. Is this also the opinion of the planning board and the planning board attorney that a resolution can be passed to retroactively apply site plan?
I don't,
I
yeah, I don't think we're really talking about that. I think we're simply talking about, our principal uses in the industrial zone subject to site plan review. I think Mr. Boomer has expressed the opinion that really we should be considering that prospectively, not retroactively. And we're really just trying to solicit feedback from the planning board. There's no action whatsoever that is on the table.
If I may ask, what is the opinion of the planning board attorney on this matter?
Mr. Supervisor, I have not offered any independent opinion on any of these issues. The planning board is in, as you appreciate, and have given the planning board a direction, an advisory opinion role, and the planning board has started that process.
Certainly, I would ask if there is going to be, any proposed action taken that the planning board get up to speed and provide opinion, because this is really their world, and the town board is very much reaching into the planning board world to try and change these laws without consulting them. So, I mean, just for the record, it seems a little strange that whether it's this matter or the next one, that these are things that should be brought before the planning board and then recommended to the town board, but it seems that the town board's driving the bus here, so
I think I can speak to that, Mr. Supervisor, if I may. Planning board informally is certainly aware of this and is certainly prepared to follow through with the advisory opinion that it's been asked to undertake. I think if I may speak for the planning board, their intention in coming here tonight was to listen, to gain as much information as they possibly can, to make an informed advisory opinion consistent with the mandate under the code.
And that's all we're asking for at this point.
My understanding though is it was having the planning board members here would be more than just them listening. It would be them giving some feedback as well.
I think, when you say look at the local law, which is next, it, under the code, which was brought to our attention, which we absolutely want to adhere to, there is an obligation that a local law that's initiated with the town board, and under New York state law, town boards frequently take the initiative on local laws. But here we send it because it involves zoning to the planning board and get their feedback. I think there was a sense that rather than send them something formal and then have them send that back and then send them something that reflects those changes, maybe it would be helpful to just get some informal feedback first, so that if the town board decides, you know what, we do want to pursue a local law along these lines, or at least somewhat closer to what the planning board may prefer than if we don't get any feedback at all. And so it's simply just an attempt to get feedback, I think, in both directions, really.
certainly I'm just trying to get a little bit of understanding of the process, because both of these things were nearly passed back in November, so I just want to make sure I understand exactly what's going on here. So just to piggyback off of what was requested earlier of a inventory of the industrial park, certainly that's something, should you all move forward with, that we would participate in. Just confirming, you guys have contacted Amrise and Heidelberg and CRH, and you're going to be doing full inventories of all of their industrial property as well?
I think that's absolutely the intent. I don't know that we've made any contacts at all, other than the fact that you've been at meetings and you've made the offer, right? But I don't think there's been a formal outreach to any property owners in the industrial 1 or industrial 2 zone. But the intent would be to get a complete picture.
And I guess just the only other thing, and then I'll sit down and I can come back if there's more discussion, but at the prior meeting when this was discussed back in December, myself and others in the audience had suggested, rather than, piecemealing these things that have been in place for a long time, that there's many significant differing opinions on, would it not make sense to, take a look at a zoning overhaul, because it hasn't happened in a long time, and task the planning board with commencing that action, so that, 2 years from now or 4 or 6, there aren't, continuous changes of things that people are reading in minutes that they weren't party to, that they think, based on reading one way, maybe not exactly what was the intent of the written law. Like there's a lot of moving parts that go into making these laws, and certainly when there's dozens of versions of charts out there that have one specific thing that's consistent, saying that all of those were in error doesn't necessarily seem like something that should be fixed by resolution or potentially fixed at all. Like we're saying fixed like something was wrong, but it's gone through a lot of review and scrutiny through many projects, and it just seems a little strange that, you know, how this whole thing went down. I guess that's all.
Okay, thanks, Nick. Yeah, and just to follow up with contacting industry, we were waiting, our office was waiting for after this meeting so that we could get input from the planning board and the zoning board of appeals in order to determine the best way to move forward.
So other than hearing from Mr. Boomer, we haven't heard from anybody else.
I would broadly associate myself with Mr. Boomer's comments, especially as it pertains to, having this maybe looking forward rather than looking back. I think it's kind of clear from this discussion that this is an administrative problem that the town itself created, that perhaps the property owner shouldn't bear the burden of having to go back and look and possibly revise anything. And then the second thing, it's just a minor sort of phrasing thing. It's the town board of the town of Queens directs to avoid confusion concerning the town zoning code and site plan review that a clean version of Schedule F be prepared. I think kind of just prefer that it direct the schedule to be revised in the way that the town board wants it to be revised. Does that make sense? Because I've been watching the meetings, so I know what clean means, but
I know what you mean, yeah. And again, that was an initial sort of draft.
Yeah, I understand.
We're not
Yeah.
seeking to.
Yep.
Sorry. I would generally agree with Mr. Boomer and Mr. Jones as well. I don't think a retroactive look is going to be in the best interest of the town or the property owners in the industrial zone. I think looking forward makes the most sense. And I think, it seems that we have willing partners within the town that would be willing to work with us to conduct that review, or maybe Jason to conduct that review. I would also make one other point, and I think Mr. Kinnery might have mentioned this earlier, but we haven't been asked yet to provide a formal opinion. I think it's just been exploratory at this point. So I think it almost sounded as if we were asked at that point, and I know that starts a time frame, but we haven't been asked as of yet. Just wanted to make that point.
That's the way I feel too. I mean, this is like the first thing I really, not that I've heard about it, but learned anything about what's going on or anything, really, truthfully. You had one meeting, but I was absent, where you guys talked about it a little bit, right? Mm-hmm. But I don't think it was anything extensive or anything where we're supposed to vote on anything tonight. We're saying whether you should or shouldn't do it.
We're just looking for your input.
We don't have an input.
Yeah, I think we're all feeling like the same thing. It's like, let's do this and figure out what we're gonna do and move on with it. So we're here to do something, so we'll get it going and take it from there.
Again, because you guys primarily deal, with site plan review and everything else, as it's been presented to you, through, at the time, Ms. Grogan, and Mr. Kinnery, there was a draft of a local law that was put on the table. There was a public hearing that was held. The public hearing was continued. The public hearing was closed. There was a resolution put on the table. Ultimately, it was tabled. So we as a town board felt that it was appropriate to solicit your input, before any further steps took place.
And I was just going to say to Mr. McGuire's point, I think it was intentional not to send anything formal because we didn't want to trigger any.
And again, this is my first time in 15 years, being on the zoning board of appeals, being on the joint board, being on the town board, that I've ever been involved in a situation where we had a joint meeting like this. So this discussion is new to me as well. So,
Because we are two separate boards.
correct. And we as a town board appoint you guys.
Correct.
So that's where I feel like there's a little bit of a gray area, you know, with us sitting down formally, even though it's informal, and even though we're not formally requesting anything from you, we are still soliciting your thoughts and opinion in a public forum.
And absolutely not trying to influence your decisions in any way. This is just fact sharing, basically a preliminary meeting to move forward. Because it's a large issue, as we know.
I'd like to ask Mr. Kinnery, would this also include the school and the high school when they do their projects?
I don't know that there has been any determination on that, and I will tell you
That's not
that.
in an industrial zone, but I
Yeah.
don't know.
But what we often see, Mr. Collins, is that those particular uses take the position with us, and you may recall some of these, where they contend they're exempt.
Correct.
And so what we'll find is they come in on a voluntary basis and will participate in site plan review on a voluntary basis. And as you appreciate, a voluntary basis for our board means that ultimately the opinion is in the nature of an advisory opinion.
Correct.
And we've seen it with some of the fire districts as well. So in those instances, we try to give them, you know, the benefit of the review, the site plan. There may even be the town designated engineer reviewing it. And then they may choose to build their project in a bit of a different manner.
What statute are they exempts them from review? You know?
I don't know if I can give you the citation offhand, but they do have a quasi-governmental exemption that they
Fair enough.
assert.
And I think there's some case law on that, maybe out of the Appellate Division 4th Department. I think there was an airport that took the position that it wasn't subject to review.
Case law not necessarily.
Fairly well established, and I think their theory is they go through a review process with state ed, and so they, you know, it's not like they can act unilaterally. They would say they have to get approval from somebody. It's just a different.
So typically what will happen, to Mr. Riley's point, is, and the case he's referring to is the County of Monroe, which actually went to the Court of Appeals, which, Mike, I'm sure you'll read this and appreciate it. But the evolution of the law was one where it was at that time, and it is an airport, they were fighting about whether or not, I think it was the airport, was subject to local zoning. And the outcome of the case from the New York State Court of Appeals, the highest court in New York, was we're not going to look at sort of a bright line test. We're going to establish a series of factors. And so that's what the case stands for, and it's been followed since, I don't know, it's probably the late 80s that it was decided. But it's that balancing test of factors, and typically what you will see, just to elaborate to Mr. Collins' point, is it comes down to a balancing test of, is it a proprietary use versus a governmental? So it's a question of what is the definition. But if government's going to run a hot dog stand for profit, proprietary. Governmental, municipal, that's where they assert that they're exempt. So we typically look beyond the label to what's the use. The school is an easy example. Firehouse, easy example. It's when government runs a business, then it becomes a bit of a question.
Thank you.
Okay.
Does the town or planning board have any opinion regarding a more comprehensive zoning overhaul?
I mean, I feel like we discussed that, and that would be a few years in doing that. So that would definitely be a discussion that we will be having, and I'm sure the planning board team will be having that discussion. And now you want to move forward? As far as the site plan review discussion, it sounds like we're leaning towards moving forward and not reviewing retroactively, which would make the next steps to plan visits and schedule meetings with industry, with Kinnery and Mr. Jamalowski moving
forward. That'd be my sense. I mean, ultimately, I suppose, Jason has Mr. Shimolinski has a statutory role as building inspector, and so, we're happy to certainly confer with you, but I'd also encourage you to confer with Mr. Kinnery and if you consider how to try and solicit that information and just try and build a record for your office so you have a sense of what the status quo is.
I guess just to confirm what exactly the building department doesn't have in their record, because it was asserted at the last meeting that they are not aware of a single tenant in the industrial park. So with the code enforcement officer here, I would ask that question of him, what information are you not?
I have knowledge of the buildings, not the tenants.
So you are not aware of a single tenant in the industrial park?
Yes, I am aware of a single tenant, yes. But there is more that you're stating compared that I know of.
I'm not stating anything. I'm just reiterating that the supervisor claimed you had no knowledge of anything that goes on in the industrial park.
Well, I claimed that I would have a conversation with Mr. Chmielewski, which I did, and he reiterated all the tenants that everyone is aware of, Curaleaf, CTI, and so forth. But I had a question of when we spoke at a meeting, and I said there was knowledge of 19 tenants, and you said, well, there's more than that. But we don't know what they are. So kind of moving forward, we'd like to get that information and just.
Has anybody reached out to Mr. Laraway and asked for a list of tenants that he has?
Not to my knowledge. My office hasn't. We were waiting
Mr.
for this.
Shimolinski, has your office reached out to Mr. Laraway and inquired?
No, I have not.
We really wanted to have this meeting first.
First.
To get a sense of how the board's felt.
I know, but, prior to this resolution being presented at the November 13th meeting, that probably should have taken place at that point. Just my opinion.
I mean, I think one of the things that struck me when I started down this sort of process and researching this issue was I was fairly surprised how little information the town has of what's going on, in terms of detail on some of these industrial properties. And certainly they issue building permits, and so I think they have information about structures, but they don't necessarily have the level of information about operations that I'm used to seeing in other communities.
And as a code enforcement officer, isn't that something that would fall under that position's role? Like if you're going through your files and you understand that you have information about buildings, but you don't have information about plans?
Yeah, generally, I think it almost, you develop that record organically because these projects are coming in for site plan review, and that's the thing that hasn't necessarily happened here.
But just like in a situation where somebody builds a deck, or somebody builds a barn, or somebody does something and doesn't apply for a permit, if the code enforcement officer finds out about it, isn't it his or her obligation to, go and inquire? Or do they just sit back and say, well, I'll just let time continue to run?
No, I think they generally do. I think in any given day, a municipal official has to decide sort of what am I going to focus on today. I think they have the authority to make some of those inquiries. Maybe with this background, they'll be a little bit more confident in their authority.
I would just offer the opinion that if we're trying to pass a resolution that at the time had 10 years of retroactivity, plus, other changes, that if this was such a critical issue and that there was the opinion of the town board that there was information missing, that it probably would have been easier to simply ask for it before trying to, make baseless accusations and try and change things without, informing the people that you were affecting. But that's just my opinion.
Would a change in tenant fall under development of any new uses and all other building or development activities? In other words, would a change in tenant in the industrial park require a site plan review?
I think it would depend on the type of change. If it was one tenant for a like tenant, then presumably it would not. If it was a tenant for a new new tenant that would require the introduction of new materials or processes not previously associated with the existing use, I don't think you would trigger.
Let me give you one example too. Say they came in for an office building that went to site plan review and got approved, and there was multiple office spaces. The owner owns that building and then rents it out to multiple businesses. I'm not gonna know about the multiple businesses because the owner got that business office approved. Does that make sense? If there's a change, yes,
And a new tenant comes in.
if they came in, correct,
Why don't you fill that up?
yes,
Just so they follow that.
yes.
Well, I think you know, Mr. Schmidt, that so if there's a change of tenancy and there's a modification that occurs, the obligation is on the building owner to make an application to the town for a building permit. And so that's how the town, at least as I understand it, would traditionally understand, or know, if you will, that a change in tenancy has occurred. Otherwise, my understanding is in Queens, there's been, prior to this date, never an indication at this town hall that there's been a change in tenancy. Some towns do require zoning verifications with respect to changes in tenancies. But here, it's only triggered, the knowledge is only triggered in town hall if there's an application for a building permit. Where's Nick? As far as I know. The only time that you've ever done anything is if you've made an application for a building permit. That the town would know that there's a subdivision or.
Special use
yeah,
permit, yeah.
Yeah, so if there's an application filed, would there be knowledge, if you will?
So in the office building, you have offices. One moves out, another one moves in and uses it for the office. You don't have to do anything. They don't have to come fill out a permit or anything.
Right, no, because it's the same use. But I'm not gonna know about that switch of a tenant or who's in there.
In the office building, if it went from being an office to a nightclub or something, right? it might
That's
have-
understandable. But if it, say you have to rip out a wall to make an office bigger for somebody else, you gotta come for that?
Yes,
You might have to come for a building permit, not necessarily a site plan review. You'd have to come for a building.
Building permit, okay, not site plan.
if it was 25% bigger, so it's 25% or more within 1 year period.
Okay. I think we have a plan moving forward. Let's say for review, we'll all keep in touch, obviously, as information.
So, just so I understand the plan, who's going to be reaching out to Mr. Laraway?
Our office will, and then we will get information from the code enforcement office.
Well, you gotta reach out to FabCon, you gotta reach out to
Everybody.
you gotta reach out to the cement company,
Right.
you gotta reach out to all of them.
And your office is gonna do that?
That brings us to our definitions. For local law, or scrap up law number 1 for 2025. The proposed owner occupied contractor yard definition. Everyone has had a chance to read these. I'm curious to see if there's any edits or additions or subtractions to the definition that our legal department has provided for owner operated contractor yard.
Earlier today. Will this discussion also incorporate, the language in the draft local law? The transportation terminal agricultural related?
Why are we not discussing that and only discussing owner occupied contractor yard?
Yes,
I think the intent is to address sort of all of those definitions collectively. And just for the benefit of the planning board, the background on that was, we were asked to take a look at this definition of transportation terminal and its application in the RA zone. We looked at the history of that. Based on our review of the history of that, it appeared to us that it would be appropriate to modify that definition so that that use was really focused on the industrial zone. At the time, we didn't want to have any unintended consequences in the RA zone, and so we proposed a new definition of an agricultural related transportation terminal. That's what appears in the local law. When we then had our first discussion on that, I think this was back in August or so, Mr. Schmidt expressed concerns that, you know what, that may actually not encompass enough of the types of existing businesses that are currently in the RA zone, and so we came up with this definition that aren't necessarily agricultural related. And so then we came up with this definition of owner-occupied contractor yard. I think if the town board were to proceed with these changes, the idea would be we would do it.
just for purposes of discussion on this, the thing that struck me about this is when I go out and look at interactive mapping from Albany County, there is a piece of property, the acreage, it sort of sticks out that you would think 10, 15 acres, something that would be small, but there is, Mr. Collins, by your property, Robert Day has 1 acre and 1.6 acres. And it appears to me that some of this falls under that language. I'm not quite sure of his business, but it looks like there is some storage of agriculture and things like that. I don't know where the acreage would be if somebody is operating with 1 acre. You wouldn't really want to put somebody, affect their business.
No, although a comment I would offer on our own sort of verbiage that we came up with, it did occur to me after we circulated this was, presumably you could have a family that owned multiple parcels of multiple acres, and maybe the owner-occupied contractor yard has been subdivided out into a single parcel that, practically speaking, is a part of the whole, but on your tax map might be a single lot that might be relatively small. And so I think that is language we would want to massage, because again, we're not trying to create sort of unintended consequences. And in fact, I think if you adopted a definition like this, it would probably put folks in a better position than they were prior to 2020, because you would codify what some of those current operations are.
Mr. Supervisor, can I make a clarification for you? That property that you were talking of, that is a B1.
Okay.
Right there.
Thank you.
So, Mr. Riley, that's what I highlighted and wrote no with an exclamation mark on it. The owner of such business activity must reside on the premises. So, yeah, because many farmers own lots that are not attached. So I definitely, if this were to go forward, I would want that removed for sure, because that does not protect them. But I have a question. You had mentioned that you had said that we were asked to look in this. I was not a part of that board. Who asked?
I mean, Mr. Stott initially raised the concern about the use of that definition of transportation terminal as an accessory use in the RA zone to effectively allow for an expansion of the industrial zone. And when you go back and you look at how those definitions were adopted, based on the minutes, it does not look like that was the intent. The intent was to ensure that your solid waste local law could properly function, but there were some unintended consequences.
So, just having sat on the planning board, I don't think there were ever any cases where any industrial was going to permanently do anything to residential, because I don't think it allows that for starters. And if that were to ever happen, it had to go to the planning board anyway, whether it was for a special use permit or So I guess I don't totally understand this because it's not like anyone in the industrial zone can say, hey, I'm going to build something on your residential land, because that's not the case. And I don't know, I mean, I don't think we've ever seen any of that where any kind of permanency was going to occur onto residential land. So.
But do you think, sorry, I thought you were.
Yeah, no.
But again, I think it was triggered because when you look at it, when the 2020 board changed the solid waste law and amended the zoning code law, they put the exact same definition for all the industrial zones. And I don't think they realized that that same terminology, the transportation terminal, was in the agricultural zone as well. And when they changed one for the industrial for the solid waste law, they also applied the exact same, to me, a very industrialized definition, because it should have been, because they were trying to change the solid waste law in industrial land. It applied to now the same definition in agricultural zones. So to me, that could provide a loophole that could, have some kind of negative consequences. Why not have a totally separate definition for the agricultural transportation terminal than you have for the industrial zones? Like, why would you have the exact same definition for industrial and in agricultural zones for the same term? It seems very odd. I mean, again, according to the minutes, it seems like they only intended to do that for the solid waste law, but I think they inherently did it for two zones with the same term and same definition. So why not clean it up so it doesn't lead to any unintended consequences?
But I do think, and if you read the transportation terminal language, I understand your position. I understand what you're saying, Mike. But in my opinion, there could be a container terminal. There could be a multi-purpose cargo terminal. There could be a transfer station in the RA. And it's allowed in the RA under this schedule as an accessory use, not a principal use,
Right.
an accessory use.
Yeah.
So I think that is something to consider as well. Like, while I think you want to say that there was an error that was done in 2020, that this language was put in, that this definition was put in, because I think at the time there wasn't a definition for transportation terminal.
No.
We had
For nothing.
We had a term,
Yep.
but we had no definition. But I do think that some of these purposes that are included in this definition could possibly be utilized in the RA district, depending on your situation, depending on how many acres, depending on where you are, I mean, if you have 50 acres on, State Route 143, you're on a state highway, you have the acreage, So again, I just want to throw that out there.
I agree, but you don't have a railway terminal, you don't have a freight station, you don't have a port.
Right.
I mean, I think if anything, you could clean that up, like I think we've done. I think to sort of what?
I think you might be reading the trucking terminal definition.
I'm not.
No, transportation terminal.
No.
I'm reading transportation terminal.
Railway terminal,
See how you
freight
get
station.
confused? But I think the owner-operated contractor yard can fit that mold as well. I mean,
Our initial attempt to, because of comments like that you could have a yard, a transfer site, storage facility in the agricultural zone. That was my initial thinking coming up with the agricultural related transportation terminal, was to pull the language that seemed sort of appropriate as an accessory use in the RA zone and to create that new definition while avoiding things like, it's hard to see a railway terminal as an accessory use to an agricultural use.
Right,
So
absolutely.
I sort of cut out some of the language that seemed inapplicable, narrowed it down, and that's how I came up with the agricultural-related transportation terminal. And then you, of course, raised a very legitimate concern that maybe didn't address all of the types of uses that currently exist, and our intent was in no way to undermine those. So that's how we came up with this one.
So why wouldn't we just keep then the local law number 9 in the industrial zone and just add a similar and take out railway terminal? Because I mean, I think everyone sitting here can say, you're not gonna have a railway terminal out in the ag RA zone, for the most part. So, I don't know. I really get very concerned trying to restrict our ag area.
I think this is, I think between the agricultural related transportation terminal and the owner occupied contractor yard, I feel like that's broadening the uses that you could have.
Well,
What if somebody has different properties and they don't live there?
I said take that as,
Well, that's, yeah. she
take
said
that out, that's
yeah.
what I said, take that out. And I don't think you should limit it as far as acres. In the town of Queens, you have to have 1.87? 1.8
$80,000.
anyway, so it's not like anybody is having this small lot with a house and they're putting 5 tractors on. So, because who's to say that someone doesn't have 3 acres and they have a tractor and something else, like, I don't know. So to limit someone who wants to do agricultural stuff in the RA zone, I don't know. I think it's an overreach.
Does anybody from the planning board have any comments, concerns with the definition, transportation terminal, agricultural related, owner operated contractor yard, or the transportation terminal definition that's currently in our code?
I guess just my question, it's more a philosophical question. If we're trying to, if we don't like this transportation terminal definition in the RA zone because we think it doesn't match the intentionality of the law, why are we trying to carve in 2 new exemptions to fit businesses that already exist in town? You know what I mean? In other words, if all of these things are currently allowed under the zoning schedule, under the transportation terminal accessory use, wouldn't that suggest that that language is sort of working as it's intended?
You want me to sort of give you my
Whoever,
I don't wanna, I'm really.
Yeah, I mean,
Listening more than.
yeah, I mean, Mr. Riley's here to give counsel. I don't know that he's here to give.
I'm just looking at him because he's cross. Right?
Yeah,
No, I know. That's kind of my opinion, you know. And that's why when I got this draft of this local law, red flags immediately went up all over the place, you know, because I was concerned that that the originator of this draft local law didn't think about all of the businesses that we really do have in the RA district. So as a result of that conversation and discussion, you know, then we had some new definitions put for us, but I don't know that anything has to necessarily change, but that's my opinion.
So comments about reworking the existing definition? Seems like what's coming up.
Well, yeah, I understand. I think that's sort of the intention. I'm just trying to wrap my head around if it's necessary, considering the current one works for the existing businesses.
How many, and maybe Jason, you know this, how many people have applied for a transportation terminal? How many applications in your time have been applied for a transportation terminal? Like I know at one of the meetings, Mr. Lukens, like he was somebody in the ag district who applied for one. I mean, are they fairly common, Jason, in your opinion?
That was before my time,
Okay.
so I'm not even aware of it.
They're not too common. And we keep saying, why change it? You know, it's really not, it's not too common. And I think between getting rid of the one that separates the I1, I2, I3 definition from an agricultural term and definition with the same exact, look, you get 2 that are gonna have the umbrella for the same people who are worried about the transportation terminal right now, and it even broadens, I think, the allowance of those kind of jobs and those kind of professions and the concerns that you had, Mr. Schmidt. So,
And I don't dispute that. You know, my question all along has been why?
I think it's, well, I said, I'm not gonna be a dead horse.
Yeah, no, I know why.
I would surmise that they are pretty plentiful all over Clemens.
What's plentiful?
The amount of people using their RA property as transportation purpose.
Okay.
Off the top of my head, I could think of many businesses that are, they may not be formal because it may have existed for many decades. but
Pre-existing, yeah.
I think there's quite a few of them.
Sure. Okay.
Any further comments on the definition? All right, that will bring us right to agriculture event center.
I have a request not to discuss this because the planning board is here and they are dealing with an issue that pertains to this direction. So I ask for this not to be discussed. They're just in the midst of something that directly affects this. And what we're discussing with the other things, there's nothing on the table. So that's just my.
They do, actually, as I think of that, they have an appeal pending, is that
Correct.
right? So-
So I just ask that this not be discussed. I don't want to impact them.
I guess my thought process would be that we solicit their thoughts and opinions individually in writing or, you know, and again, this isn't an official request for a recommendation. If you just, you know, shot us an email and told us what your thoughts were based upon this draft of, you know, definition, it would help us. Because ultimately, you guys are going to be involved in.
Right, ultimately, if the town board decides to entertain a local law, we'll send it to you for the formal feedback.
Right.
But if there's obvious sort of comments that you have up front, it's easier for us to get you a draft that's a little bit closer to what you might want.
Yeah. And there's blanks in this definition, so maybe you can provide input as to what you think should fill in those blanks.
Yeah, I think that's appropriate. Trish, thanks.
Yep.
That brings us right to the separation of the planning board and zoning board of appeals, the PBA, into two separate entities again. I would absolutely defer to the PBZBA to hear your thoughts and comments on it.
Well, my first thought is, why? I don't, is there a reason why we wanna have two separate, because my understanding was that when we originally combined the boards, it was done so that we could streamline the process of, it's, you know, we only would have we'll have 2 meetings a month. That was the same time we started doing that, to try to streamline things so that when there are people in here for whatever project or thing that's going on, that we can kind of get it moving, even though it has caused us some issues in the past because the county is still on a 1-month meeting rotation, so a lot of times we get stuck waiting on the county anyways, but at least it gives us more time to address these things and stuff like that. But I was just curious why we want to split it up now.
You want me to go?
Yeah.
Okay. So this has been discussed a lot, and I have a lot of input because I was on the zoning board of appeals when it was a separated board, and I was on the joint board. There were some applications that came through recently that, in my opinion, did away with the checks and balances. So it's really hard, in my opinion, this is just my opinion, it's really hard to come to a meeting and say, okay, I'm gonna put my planning board hat on.
Right, I understand.
And then
that.
immediately after, now I have to put my zoning board of appeals hat on.
Mhm.
And I think it's hard. It's hard to separate the duties, and I think it removes the checks and balances. Now, as far as efficiency is concerned, my opinion is we should still streamline and be as efficient as possible.
Okay.
And my opinion is if we were to split this board, that we would do 2 planning board meetings a month and we would do 2 zoning board of appeal meetings per month. The chances of us needing 2 zoning board of appeals meetings per month
Right,
is
right.
slim
Yeah.
to none.
No, I know that.
In fact, when I was on the zoning board of appeals, we went 14 months straight at one point in time during my tenure with no meeting. So the zoning part really doesn't come up all that often.
Okay.
But I do think that there is a better checks and balances, a better system, provided we can make it so that it is still streamlined. Because I certainly, by no means, want to remove that streamlining process. Because I think we've gotten to a point where that's really important and good for us and
Yeah,
for the
it doesn't matter to me what happens. But you said, so you're gonna put your planning board hat on, and then you're gonna put your zoning hat on, in the same meeting?
No, it wouldn't necessarily be the same meeting.
Right, so you could put all your planning board meetings. If you have a zoning, you could make the next meeting just a zoning meeting. That's just an idea.
Yeah.
That's just an idea.
I don't necessarily have a problem with it.
No,
I
I-
just, was just curious how it came about. That was
If we
that
do,
was my only
If you
question.
do, I wanna be on the planning board, cause that's.
Well, that's,
I don't wanna be on the zoning.
that's the other issue. The issue is if we do end up splitting the board, we have enough problems trying to fill the slots that we have now. Now all of a
Yeah.
sudden, we're gonna create a separate board. We have to try to get, 3 to 5 other people.
And they gotta be schooled on that, a little bit.
I'm sure most of those older members still live in town, right? Mr. Schmidt, I was on the planning board when it was a separate board. Mr. Collins was there too, right? I think 2 meetings a month definitely makes sense for the planning board.
Don't push it.
I think during my tenure, the zoning board met maybe 1 time or 2 times, right?
Yeah.
And as you said, there's not a whole lot of activity for the zoning board, but, scheduled 2 meetings and as needed. And I think the whole point is to try to get these, review them, right? Provide insight and guidance for these projects, but try to get them reviewed, right? And having multiple meetings a month definitely helps in that process.
Yeah.
So,
Right, but also, just last year, we had 2 site plan reviews that required special use permits for the 2 projects. And we have another one starting now. And they take a year for them to get completed.
Correct.
And they were both solars, and now we have the trailer park coming in. It's not like it was probably when you were on the zoning board.
Right.
It has blatantly progressed.
Where the original site plan review law was implemented, was that to the planning board or the zoning board of appeals?
It would have been the planning board.
Yeah.
I think that the change to combine the boards was early 2020.
Yeah.
So,
But that's sort of the hard part in the town code. There's no separation. It's all just now referring to the single board. So we had, I think you told me we had 1 variance and 1 appeal last year. Is that correct?
1 area variance, 3 lot line adjustments, 1 appeal.
Okay.
I'm trying to remember my report now.
the lot line
Site
adjustments,
plan review.
they wouldn't go before zoning. Right?
No,
No.
that would be planning.
Just the area.
Zoning would do special use permit and variance.
Yeah, that's it.
Yeah, area and use variance. Or interpretation, or an appeal from the building department, yeah.
And I think in my 4 years, we had an interpretation, 2 appeals, maybe 3 or 4 more. Wasn't like a dozen.
I mean, my personal opinion, I don't know if my colleagues feel the same. I don't really know if there's wisdom in creating a body that will only meet 3 times over the span of 2 years, but, that's just me.
The one thing that stuck out to me is if it's an appeals board, has anybody ever reversed their position from the planning board decision to their zoning board of appeals hat and went, yeah, I was wrong?
Just as a matter of procedure, it's not an appeal from a decision of the planning board, Mr. Supervisor, so that particular circumstance, I don't think our board members have had that experience. So typically, the appeal is from a denial of decision from the gentleman to my left. And so that's the decision that's usually on appeal. And an interpretation is generally a de novo review at the zoning board, so the planning board hasn't seen it.
Right.
And generally, it's considered that the planning board is just, as Mr. Schmidt will probably complain about as a former planning board member, constrained by what the code is. There's no real interpretation power at all at the planning board level, whereas the zoning board of appeals considers statutory factors to make the decision, but on an interpretation, they have a little bit more flexibility. The planning board does not have that, so they're very different powers.
Can I ask what your representation consists of with other towns? Like how many planning, zoning there are, and are most of them separate?
For me personally, I mean, I will tell you, generally speaking, they're separate. There are others. If you said to me that, you know, can I cite an example of others that exist? They do exist.
The village of Ravena has a joint board.
Right.
Not a Western one.
And I will say, for what it's worth, I mean, I think, Mr. Schmidt, you did a good job of summarizing the factors to be considered in terms of the decision that you all have to make. And I do think a practical factor is the spirit of volunteerism.
Right.
And then you'll see in the legal commentary that there's always a discussion about, can a board member at one of those meetings effectively switch and put their blue hat on for the zoning board and then put their green hat on for the planning board on that agenda. But I mean, to tell you that these combined boards don't exist, Mrs. Grogan, they do. There are boards that are out there that are combined.
Thank you.
All right, a lot to think about, okay. That brings us to public comment time. If anybody from the audience would like to speak, step to the left.
Barbara Tanner. I thought the reason that they combined the two boards was to make it easier on the people who are applying. Instead of going to 2 meetings or 4 meetings, they're going to 2 meetings a month. It's bad enough the red tape that you have to go through, period, but then they have to go through 4 meetings, maybe 8 meetings, maybe 12 meetings. Isn't that why it was done? Nobody knows?
I can't speak to why.
In theory, I think that's what they meant to do with it, don't you think?
Yeah, so the rationale behind joining the boards was for efficiency purposes.
Right. Right. And so you're gonna do away with efficiency?
No, I mean, if the town board were to decide to split those boards, we would make sure that the efficient manner was still put in place. No.
Yeah, but Steve, it's still gonna be 4 meetings as opposed to 2 meetings.
Well, you wouldn't have to go to all 4 meetings, you know,
What's
but
that?
you wouldn't have to go to all 4 meetings. But we would schedule enough meetings so that essentially you could go to the planning board if that's what you needed to do. Like, let's say you have a site plan review, right? You have a site plan. So you go to the planning board. You go to that first meeting. Then they tell you, well, you may need an area variance. So you're gonna have to go to the zoning board of appeals now. There's still a meeting, a zoning board of appeals meeting that month. So the applicant would go to that meeting.
Right.
And then the zoning board of appeals would do what they had to do, and then the applicant would go back to the planning board. I mean, essentially, you're still going to end up in the same end result. You're just going to have more checks and balances put in place.
Okay. I'll let you have your way, but I disagree with it.
It's not my way, it's.
Further comment? Hearing none, we'll make a motion to adjourn.
I'd like to, hang on a second.
Sure.
So you're gonna look into the companies, all the
Yeah.
FanCon and everything, you're gonna write let it go on with call and everything like that? And if there's gonna be no resolutions for the next meeting on anything we talked about or anything?
No, and I probably will be reaching out to a lot of the planning board, zoning board members for input.
Consider it a fact-finding mission, will there be a follow-up joint meeting?
I'm sure, yeah, absolutely. Okay, comment, and I make a motion to adjourn.
I second that.
All in favor?
Aye.